Dario Dosio. I'm a judge at the High Court in Johannesburg and South Africa. Well, there was approximately about 300 cases that were kind of determined to go for prosecution. And I think there's been a lot of delays in doing that. I think one of the biggest problems was political compromise. I think due to the fact that there was a lot of compromises made to grant amnesty or not to grant amnesty, and also the newly elected government, I don't think wanted to be regarded as unstable. It could have caused serious problems from a minority group. So as a result, I think the compromise led to some form of impunity, unfortunately. There were other issues as well. There were other concerns that came out after the Truth and Reconciliation Commission. We went into the elections, the first democratic elections. Government needed to concentrate on that. Government needed to ensure that those political elections went smoothly. And unfortunately, after that, there was a big HIV pandemic. And after that, we then had the state capture problems. So there's been a lot of hurdles that have interrupted these cases coming to court. I think that's one of the biggest problems. I think there was also the issue that the NPA has also been criticized, that they were probably a little bit influenced by the executive. There's been a lot of changes in the heads of the national directors of public prosecutions over the past 3 years from 1994. And this is seen by the victim families as being reasons why these matters did not proceed as quickly as they should have. This is one of those matters that originates from 1982. It was 4 youth. They were lured by state officials of the Apartheid government, and car bombs were used to basically kill 3 immediately, almost on impact. The fact why it's so important is because families have been requesting for many years that these cases come to court, and because there's been these delays, there's been this continual request that it needs to be expedited. Obviously, the families are growing old, witnesses are growing old, the accused themselves are growing old, and why it's drawn so much attention is because there's been a lot of interlocutory applications before the matter could even start. I was granted the opportunity to start the matter. It's not, the accused haven't pleaded as yet, but what transpired is when it came before me, there was an objection raised that basically the state couldn't prosecute because of these delays that had been encountered over the many years, which I regarded as being unfortunate. But I did not believe that was a ground not to start the matter. In addition to that, there was also the objection raised that even although South Africa had adopted the Rome Statute in 2002, and because it didn't apply retrospectively, that because these crimes happened in 1982, basically the state had no right to prosecute. So why it became so important is because the state took a different avenue. They decided not to prosecute then in terms of the Rome Statute, but rather in terms of Section 232 of the Constitution, which looked at whether there was violation in terms of customary international law. And because it's the first case that has had to deal with that, I think that's what gained momentum and increased the interest in this matter immensely. And I think because of this 40-year delay, families are really quite agitated that they want this matter finalized. So all those reasons cumulatively, I think, are adding to the stress that the family victims are encountering, but equally also the stress that the accused are countering, because the accused have been standing on trial for quite some time. Their matters do not start. So as a result, they also don't know where they stand. And the matter is now currently in the Supreme Court of Appeal because they are challenging my decision that the state could proceed in terms of customary international law. The fact is, open source technology has already been used to a certain extent, because we had the Marikana Commission of Inquiry where miners were killed by the police forces. The defenses raised by the police in the Marikana matters were that they were acting in self-defense. When a lot of the cell phone video footage was shown, it was clear that that was not the case. So the Farlam Commission that was tasked to deal with this actually accepted such evidence, but it has not really been used in trials in court. But in conclusion, I think we are using it. It's just a matter of having reliable evidence. As I say, there's no reason why digital information cannot be stronger or any on the same leg or same standing as paper-based information. South Africa was one of the first countries in Africa to be a signatory to the Rome Statute, and I think we have shown an ability to apply, the Rome Statute in the sense of the Al Bashir matter in 2015. I do also believe that we have a judiciary that is well recognized. I think our Judicial Service Commission that appoints judges has a good track record. We have a strong record on rule of law and our independence as a judiciary. So I think if we're able to put in all the mechanisms that will assist, we could most definitely become a leader. We're economically strong as a country, and I think we do have all the technology that would be required should these matters be heard, in court, be it through technology, video links. We're quite well advanced in that regard. So yes, we could most definitely become a leader. Well, I think South Africa could gain, the respect of the rest of the African continent. I think our constitution is well recognized, that we have a legacy out there. And I think, in addition, this would just be hopefully another legacy that we could fulfill.